Welcome to the Bail in the Midwest podcast, hosted by Shane Rolf.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 35 years. Now, not only am I the Executive Vice President for KBAA, I'm also the Legislative Chair, which means I get to listen to a lot of testimony before the Kansas House and Senate. And so I hear a lot of catchphrases, especially from bureaucrats and so-called reformers who seem to have their own language of self-importance. But two catchphrases are my personal pet peeves. One is evidence-based, and two is data-driven. And whenever I hear one of those terms, I now automatically assume that there is neither evidence nor data to back up this speaker's claims. And this is particularly true when it comes to bail and pretrial release. Now, in 1994, the Bureau of Justice Statistics released a report titled Pretrial Release of Felony Defendants in 1992, which gave a lot of information about the pretrial process for felony cases in the 75 largest counties in the country for that year. Who got out, how long it took to get out, how many failed to appear, how many were rearrested, et cetera, et cetera. The Bureau had released similar reports in 1988 and 1990. However, the 1992 report was different because for the first time, it compared the appearance rates for different types of pretrial release. That study showed that surety bail releases had the best appearance rates of all the various types of pretrial release by a pretty wide margin. For example, own recognizance bonds failed to appear 73% more often than traditional surety bail. Even supervised pretrial release programs, which were all the rage at the time, had FTA rates or failure to appear rates at almost 30% higher than bail bondsmen, despite the fact that bail bondsmen normally got the people who were considered high risk in the first place. This data was so damning that the federal government stopped releasing these reports. And it took a literal act of Congress to get them to do one more that was released 14 years later. However, that was released with a caveat that one shouldn't draw conclusions from the data. The results, however, were largely the same, and the federal government hasn't done another study since then. So since that time, actual data has been hard to come by. Yet the bail reformers still claim that their ideas are data-driven and evidence-based. My guest today has taken upon himself to actually compile and analyze the results of California's zero bail policies that were enacted on a, quote, emergency basis, unquote, during the COVID pandemic. Jeff Reisig is the district attorney for Yolo County, California, and has been one of the few people in his position to compile and release actual data on this topic, particularly as it relates to the impact of California's zero bail policy on overall crime. Jeff, welcome to the podcast.
Morning. Thanks for having me today. Appreciate it.
Well, thank you. Go ahead and give us a little bit of your backstory. Normally, I've got a little bit more background, but I'll let you hit all the high points. I know you've been in that office for quite some time, so tell us all about yourself.
Sure. Well, Jeff Reisig, I've been a prosecutor for 28 years in Northern California in a county called Yolo County, which is right next to Sacramento. So we can literally see the state capitol from my county line. Some of our bigger jurisdictions, West Sacramento is in my county at the gateway to the capital of California. And I've been the elected district attorney going on 18 years, which makes me right now one of the longest serving in California. There's only 58 counties in California, which you know is 39 million people. We're bigger than every state west of Texas combined. And so out of those 58 counties, I've been in longer than almost all of them. And this issue on bail is something that I've been passionate about for a long time because of the consequences that we have seen and documented carefully when people are released on zero bail.
So what caused you to become a prosecutor? I know I've talked to lots of prosecutors on the podcast before, and they all kind of have a different path that led them into the prosecutor's office. Was it a calling? Was it just the first job you got out of law school and that was what you loved? Or how did you end up in the prosecutor's office?
Yeah, I think it was a calling. I mean, I did dabble in civil practice and some other areas of law. Believe it or not, I worked as a public defender intern for a few years before I became a prosecutor. And that experience was very valuable for me, understanding the other side and what goes on in the other side. But this is my career. I'm going to retire as a prosecutor. I'm not going to do anything else. And so I'm a lifer for sure.
So how do you, just on a personal level, I know I've seen a lot of prosecutors and public defenders as well who really grow weary of dealing with the criminal justice system, and particularly, accused criminals, and move on to other areas of the law. How do you not become, jaded or hardened or just burned out over the process?
Yeah, that's a great question, because in California, it's really hard not to get down, because this is a crazy state these days, and our criminal justice system has been turned upside down. But I'm a fighter, and I'm not going to give up until I'm ready to hang it up. And right now, I'm still very passionate about trying to save the state from some of the terrible policy decisions that have been implemented over the last decade in particular. And the zero bail policy is one that's very, frankly, it's terrifying to me, seeing what it's done here on a temporary basis. And then, of course, in other parts of the country, it's a disastrous policy that's getting people really hurt and killed. So, I'm still in the fight. Well,
now, like I said, you're a California prosecutor, and what out here in flyover country, all we hear about California prosecutors these days are George Gaston and Chesa Boudin and these so-called Soros prosecutors that are really just radical public defenders who managed to get themselves elected into office, and they seemingly are bent on breaking the criminal justice system. But I've looked at your Twitter feed, and some of the tweets there could be like Fox News headlines, but at the same time, you're advocating for what many view as progressive policies, restorative justice. And I think you talked about before that you were one of the first, if not the first, DA's office in California to implement implicit bias training in your DA's office.
Yeah, that's all true. And so here's the thing. I reject progressive as a definer, because that term's been hijacked by some crazy people on the far left. And you're absolutely right that we have just there's actually only 2 or 3 DAs in California that are in that camp. You named LA County as one. I mean, we've got a couple other problem areas. And you said it perfectly. I mean, they have given up the mantle as prosecutors and surrendered to some radical ideology that's more about deconstructing the system and getting people out of jail. And that's not me. My approach as a prosecutor, first of all, prosecutor is a nonpartisan position in California. It's not that way everywhere, but I've been able to run in a deep blue county. My county is deep blue, hasn't voted for a Republican since Eisenhower. But I run as a pragmatist and somebody who is, interested in balancing the equation between accountability and deterrence and second chances for people who earn it. And that's what I've done. And the programs that I have pushed forward, some say they're progressive. I say, no, they're just innovative. And I've got the data that shows they're working. And so, I don't think it's fair to reject any policy that talks about restorative justice or implicit bias as total quackery, because it's not. It just has to be implemented with measure and with common sense. And so that's what I'm doing. But I think it's fair to say that I'm more of a law and order prosecutor for sure.
No, absolutely. And that was the impression I got from you just looking at your Twitter feed of other things. But I would like to touch on the restorative justice, because, a lot of times we hear that as just a catchphrase. And I've seen judges come into office and go, I'm a big supporter of restorative justice. And you're just like, oh, not another one of these. What does that mean? How does that actually work in practice?
Yeah, well, I have the same reaction you do to a lot of the restorative justice narrative, just to be clear. And it is, that's one of those things that has been embraced by some of the folks on the hard left as the solution to all of the problems. That is not accurate. Restorative justice, if it's used strategically, can be a very effective alternative to a traditional prosecution. And the way we use it in my county, and I really started this in California, is identifying, the right types of individuals and the right crimes that may be appropriate to do an alternative to a traditional prosecution. And for me, that conversation starts with the victim of the crime, where I'm reaching out to the victim and I'm saying, listen, we have another path that involves essentially a reconciliation, a mediation, carefully facilitated, where we're going to make you whole. The goal number one is get you whole, whether you lost money or there's some damages. That's the number one goal. Are you interested? And if the victim says, no, thank you, I want a traditional prosecution, we go traditional prosecution. But if the victim is open to it, we will engage a process that's very complex, and it involves exactly what I said, which is a facilitated mediation between the victim and the offender. The offender must accept responsibility for the crime before they go into this program, to be clear. And from that point on, it's just about trying to reach a satisfaction of all of the victim, number one, the community, number two, and get this offender rehabilitation or whatever it is we think they need to get them on track. So to me, that's restorative justice, and it's a victim-driven process, 100%. It's not something that can be compelled upon victims by anybody. And that's where it gets abused by a lot of the radicals, as they try and apply restorative justice by force upon victims and communities. And that never works, and it undermines confidence.
Or they just leave victims out of that equation altogether.
Yeah.
So, I mean,
it's a travesty.
It sounds sort of like a combination of some rehabilitation programs and maybe like an old Anglo-Saxon weregild style of justice, where it's, okay, we're going to figure out what's going on. You owe them this much money or this much, compensation in whatever fashion that is, and we're going to solve it that way. And everybody, the entire tribe is part of that.
That's exactly right. I mean, it has ancient roots in history, with tribes going all the way back to, Australia, and the ancient tribes there used restorative justice to resolve disputes within the community. And so it has long history, and it has a track record of success when it's used wisely. But I mean, just to be clear, that is a small tool in my toolbox as a prosecutor. We use it on probably less than, 5% of all of the cases. And again, only with the consent of victims. So I think it's something that is legitimate when used strategically and with common sense.
Well, and then you would still have the prosecution aspect of it as a hammer if that doesn't work out.
100%. Yeah, that's right. That's always sitting there. Sort
of like, various different drug courts, yes, we're going to offer you this path to go forward. But, if you don't, we still we have the sort of Damocles hanging over your head out here.
Yeah, carrot and stick works.
Yeah. Oh, absolutely. So let's just hit the other not progressive policy, the implicit bias. I think a lot of people, view implicit bias training, at least in its current form, as just another type of DEI and little more than a tacit admission that the criminal justice system is racist as a whole. And I've always argued that those in the system should push back strongly against these claims of a racist criminal justice system. People really do need to have faith that the justice system is impartial. So how does implicit bias training work in a prosecutor's office? I heard some of the story as far as it just reminded me of when my son was in band and they were doing auditions there, and it was completely a blind audition. But how does that work in your office?
Yeah, it's a great question. And I'll start by, posing the question to you and your listeners. When you think of Lady Justice and the scales of justice, what does she have around her eyes?
Oh, yeah.
She has a blindfold. And that goes back to the formation of our system, the idea that justice will be blind. Now, there's a lot of ways to interpret that. But on the issue of implicit bias, the way we interpret that is we want our decisions to be totally unaffected by any type of bias that any of us might have towards anybody of any other race, whether it's, black towards white, white towards black, white towards Hispanic. I mean, whatever. The fact is, and I don't think anybody would disagree with this statement, we all have biases implicitly. Like sometimes they're subconscious, but they're there. And so in the criminal justice system, this idea of just being aware of that, number one, having all of us just be honest, like, look, you can't just say carte blanche that there's no issue ever with anybody. No, I mean, you have to be aware of it. And so implicit bias at its, foundational stage is just about recognizing and training prosecutors to be open to that idea and take precautions to ensure that these decisions we're making to charge people with crimes is not being affected by any of those biases. That's it. And you made the statement that, our system is not systemically racist. I agree with that. I do not think, I've never seen any evidence in California that our system is systemically racist. And I have heard that again and again. And, what I say is there's always bad actors in any profession, right? But
sure.
The system as a whole is mostly dominated by, righteous people who are trying to seek the truth and do the right thing. But The second part of the implicit bias training, especially in California, just to be candid, is building confidence in the public. And when we, engage in the implicit bias training, and we have another tool, it's actually a law now in California, which is called race blind charging. And it's exactly what it sounds like. When we make a decision to charge somebody with a crime, the initial review of the police report is without any information on the race of the suspect, the victim, the witnesses, or anybody. And we're making a preliminary decision as to whether we're going to charge or not before the entire report is revealed. That was something that I implemented a few years ago. It's now a state law in California, and it embodies the same idea that Lady Justice is blind, and it builds public confidence that race is simply not part of the system. And my last comment on this is the biggest opponents to the race blind charging that we have done in my office and around California is from the progressives. They don't like it because this is my assessment, it's taken away an argument that all prosecutors are racist. They don't have that card to play anymore because of the system that we have. And so I view it as procedural justice for the public, but it's also prophylactic for the attacks from the progressives that want to make everything about race.
Well, it's kind of like when, there was a big push and still is a big push for body cameras for law enforcement. And, we got to have body cameras and that'll prove that what's really going on here. And what really turned out to be is that was just another tool to be able to convict people because people admitted things on those body cameras and they didn't show what, the assumption was there. And now there's like, well, maybe we shouldn't have some of these body cameras.
Yep. Yeah, it's a great point. And, the body cameras, frankly, have helped us in many, many situations prove that the officers were absolutely right and that the witnesses were lying. So that's another great example where transparency has actually revealed more truth in the criminal justice system with the body cams.
Well, and we've taken to using those ourselves when we go to pick people up. It's certainly nice to have that because there's always some claim. And then, when the police respond, well, what really happened? Here's the video. This is what really happened. And, and it just shuts down all kinds of things. But so anyway, before we get into some of the data you've compiled, kind of set the stage for us, what was going on that would allow you to make these sorts of comparisons. Obviously COVID, but how was that working out in your area to create a deal where you could actually make these sorts of zero bail comparisons versus bail comparisons?
Sure. So in 2020, as COVID was ripping across the country, California, as you probably know, took a very aggressive stance in responding to COVID. And one of the first things they did is the California Supreme Court issued an order of implementing zero bail on all 58 counties in California. So it came down from the top, instructed every single, county sheriff, DA, court system, implement zero bail on a whole litany of what they call nonviolent, non-serious felony offenses, many of which I consider serious, but by law they were not, like auto theft and burglary and things like that. And then also a slew of misdemeanors. Well, the mandate stayed in place statewide for only 3 months before the Supreme Court said, okay, counties, we're going to let each one of you decide how long you keep this zero bail order in place. And unfortunately, my county, my judges who control the bail schedule, and in California, that's important to understand, it's the judges who set the bail schedules in every county in California. And so my judges made the decision to keep zero bail in place for 11 months. And during that period of time, I was very concerned about it. And I made a commitment to start watching and tracking these individuals who were being released on zero bail. And the short version is within weeks of the policy being implemented, we were seeing recidivism, repeat crimes by some of these people who were released on the zero bail policy, sometimes within hours of being released. They'd go out, they'd steal a car in the morning, they'd be released and steal a car in the evening and be released. And the next day they'd be burglarizing. And so we started to keep track of it. We were putting out a lot of press releases to keep our community informed. I was disappointed that out of all of my colleagues in California, the 57 other DAs, none of them did that. I was really the only one that was pushing the information out. And because we were keeping such close track of the data, there did come a time where I then decided that I was going to do a full study on zero bail versus a control group from a prior period.
So you actually did two studies, though, correct? I mean, you did one initially that looked at all the zero bail releases, and then another one that looked at comparisons. And did I get that right?
Yeah, you got it right. The first study we did in 2022 was just looking at the recidivism rate for those who were released on zero bail. And so we took a sample we looked at all of the folks who were released on zero bail in my county, which were, close to 600 felony and misdemeanor zero bail releases. And we tracked them statewide for a period of 18 months to see what was their recidivism rate in the wake of the release. And what we found is it was 76%. It was very high recidivism rate for those individuals released on zero bail. We published that, did quite a bit of interviews on it. I did go on Fox News. I went on CNN too. I mean, we talked about the data, but the criticism that came from the bail reformers was they said, oh, well, your study isn't good because you don't have a control group. We don't know. 76% may not be that bad. People on bail may be reoffending at the same rate. And I said, okay. And so we went back to the drawing board and did a second study that we released in 2023, February of 23, that actually took the sample of zero bail releases during that period of time, the COVID period, and we compared it to a similar sample of people released on traditional posted bail during a previous period in time. And so it was an apples to apples comparison in demographics and crime types. The only difference was the timing. And what we found, not surprisingly, is that the reoffense rate for those on zero bail was through the roof compared to posted bail. In fact, it was 163% more crime committed by those on zero bail than those who were released on traditional posted bail. And in violent crime, those released on zero bail committed 200% more violent crime than a similar group released on posted bail. That study got a lot of attention for obvious reasons, and it's frankly created a lot of concern and worry, from folks who want to reform the bail system.
Well, and just so I get my statistics right, a 200% increase is not a doubling. It's actually a quadrupling, is it not?
Yeah, well, I think that's right. I'd have to look at the raw numbers, but
I mean, 100% would be a doubling, and then 200% would be a doubling of that, if I recall. So, I mean, it's basically 4 times, more crime being committed, by these zero bail releasees. Now, I did read over that, and it is kind of a small sample size. I mean, you're only dealing with 100 things, so I'm sure there's some criticism about the sample size, and can we make large scale extrapolations from that sample size? Like on the violent crime, for instance, it looked like the bulk of the increase was in domestic violence. So I would assume that, people are going to argue, if they're going to try and argue against that, is, well, it was COVID. And so people were locked up in the houses together. They were frustrated. They lost their job. And then, domestic violence was just an outgrowth of the COVID response. But on a macro scale, comparative data aside, were you seeing an increase in the raw numbers of violent crimes, that were being reported following the zero bail release, just in raw terms?
Just in raw terms, yes, we were in California, but I want to address one other thing you said about the sample size. This was a sample of 100 versus 100.
Right.
The experts that helped us with this data said it was entirely statistically relevant. The sample size was appropriate. There was nothing about this study where you, from a statistical point of view, can really attack it as not having merit based on the sample size. And what I would say to you is, when we hear about presidential polls, you look at the sample size on a national poll, and they're talking about 1,000 maybe.
Right.
Right. And so here we're talking about 100. So there's no merit to attacking this study by saying the sample size is too low. I've dealt with that, and we've got statements from economists and PhDs saying, no, that's not accurate. This is a good sample. So that's not accurate. As far as the argument that, during the COVID period, this was the argument. They criticized this sample by saying the comparison group that we looked at in the run up, because we looked at this comparison group immediately before COVID, and the argument was, well, during that period of time there was increasing crime due to the anxiety and economic social conditions post George Floyd.
Right.
Okay. And so they believe that then was creating a problem in the data. We've fixed that, and we're actually getting ready to publish a third study that will be coming out in the next few weeks here. And what that third study is going to show is we looked at a sample size that not a size, but a period in time that will satisfy these researchers, and the numbers just got worse for zero bail. The numbers just get worse. So,
go ahead.
Yeah, and that's, I think, the two things about the study is the sample size is fine. The data only gets worse as you look at, different periods of time before COVID. And the fact of the matter is the crime rate in California during the height of COVID did go down to the extent that there was the lockdown kept so many people off the streets. There was an overall decrease in some crimes during the initial lockdown. That changed as we got late into 2020.
Well, and one of the things I've always talked about with my people here is that, the weather has a huge impact on crime. In other words, if it rains or something, nobody can go out to the nightclub and get drunk and get in trouble. And so you have a change in what goes on. But if the weather stays consistent for a while, well, then people will go back to their normal routines. Obviously, COVID was not the weather, but it was a huge shock to the system that put people out of their normal patterns and rhythms. So if we couldn't go out to the nightclub, well, then maybe we aren't going to get in, the same follow-up kind of trouble that we would get out from being intoxicated under the influence or something along those lines. So that would make sense.
Yeah.
Now, that first study looked at like your 600 releases, and you said it was 76% of the defendants were rearrested, and 20% of those arrests were for violent crimes. That makes sense to me. That feels correct. But how do we square that with claims out of places like Harris County, Texas, and New York City, where both of those locations claim that only 2% of their zero bail releases were rearrested for a violent crime?
Yeah, so I haven't closely studied those, but a couple of things that I have noticed about other studies that I've looked at. First, we were looking at a statewide recidivism, not just a recidivism in my county. And many of these studies, including one that just came out of Los Angeles, which you may know, your listeners may know, Los Angeles County adopted a zero bail policy earlier this year, but after a court case. And they quickly put out a study, some of the supporters of zero bail, a month or two after this program had went into place. And they were touting the fact that recidivism was pretty low, but they were only looking at crime committed in LA County. And the fundamental flaw in that, as you know, is, criminals rotate all across regions, and, LA County to Orange County to San Diego County to, in my neighborhood, Sacramento, Santa Clara, San Francisco. So our study is a statewide study. It's truly a recidivism across California. Many of those studies that I've looked at, I'm not sure about the Harris County, are usually more myopic. That's the first thing. The second thing is, I'm not sure exactly, who the individuals are that they're tracking in those, and are they truly zero bail releases in every instance, or are they being released with an ankle monitor, some type of supervision, some type of check-in requirement? That's one of the criticisms that I have of some of the studies done out of New Jersey, is they have a very different bail system out there. When they say somebody's released without bond, that doesn't mean that they're just walking out the door without any supervision or any monitor. They have all of that. And in California, make no mistake, when we have zero bail, it means they're immediately released without any conversation with the victim, without any ankle monitor, without any supervision at all. They're just cut loose out the back door.
And it's just a charge-based release, not based on any sort of criminal history evaluation of the defendant?
Exactly.
So, I mean, you could be having someone who's on parole for murder being released out because they got charged with, an auto theft, and they're just walking out the door.
That basically happens all over. It happened all over California during zero bail.
Well, and you mentioned New Jersey. One of the things that I've always found distressing about New Jersey's deal is they changed around a bunch of their definitions. They changed around how they defined failure to appear. Used to be that a failure to appear was if you posted bond and you missed court at any point during your case, that was a failure to appear. You had one bond and one failure to appear. And New Jersey, in evaluating their program after they went to this preventive detention and zero bail release sort of mix that they have, they changed failure to appear to mean you failed to appear at one of your settings. So, say if your case had 10 court appearances and you made 9 of those and missed the 10th one, like for trial or for sentencing, well, that was only a 10% failure to appear rate. It's like, well, that's not really the way the whole failure to appear rate is supposed to work. You're supposed to show up until your case is taken care of. And so that was one method that sort of those numbers were skewed along those. About your study, though, what I did notice is it didn't really address failures to appear. I know it was focused more on recidivism and what was the societal aspects of that. But did you look at what the failure to appear rate was, or do you have any loose understanding of what the appearance rate was compared to across the zero bail versus the surety releases?
No, we didn't look at that at all for a variety of reasons. It's just complex, but the data was not good. It wasn't good enough for us to study it. And during the COVID time in particular, things were so loose in our court system. We had people appearing via Zoom,
right,
on felony offenses. It was just quite chaotic.
No, that's understandable. And it just like that New Jersey reference, I mean, it is hard to come up with a straight definition of that. I mean, if somebody misses court and they come back in 25 minutes later and the judge reinstates their bond and gives them a new court date, well, do you count that as a failure to appear, or do you not count that as a failure to appear? It's easy to look at things and say, well, yeah, this guy was gone for a month and a half. Well, that's definitely a failure to appear. But there's just so many variables that can be added into that. So this is a question that was actually posited to me at the legislature here just not too long ago. And these bail reformers claim that people are languishing in jail because they can't afford bail. But then they follow that up with the argument that most people get out of jail anyway. Despite the seeming conflict between those two claims, it is true that most people are able to secure some sort of pretrial release. So the question that was asked of me and that I also asked a lot of people is why does financial bail release work? I mean, it does work. Your studies evidence of the fact that it does work to secure reduction in failure to appear and reduction in overall crime, while other forms of pretrial release have the opposite effect. But it's the same people getting out. Wouldn't you expect the same behavior from those same people, regardless of the type of release? Or how do we explain away the fact that there is a different result?
Yeah, I mean, this is, my opinion based on my observations many years as a prosecutor and watching what happens when these folks are released. But, with a traditional bond release, a couple things happen. One, you've got money on the line, first of all, and a lot of times that money, the bond, is being paid for by family members or friends or support network or people that are going to be standing by when that individual is released to keep them from getting in trouble and having them taken back into custody, fleeing and having the person lose their bond money. And so I think that's really at the foundation of why bail works. Is there is this built-in, and not to mention the bondsmen. I mean, my experience with bondsmen in California has been they're vital partners to the entire public safety system. They obviously have an interest in making sure that the people that they are assisting return to court and stay out of trouble. Many of them are checking in with their folks, helping their folks. That's all good support. And so I think that's one way you can explain the discrepancy in the system. And that may be the biggest. I mean, I think that's the biggest that I can think of at the moment.
Well, I think Ken Good, who I think has interviewed you in the past, also has made the point that oftentimes jail itself is poor man's rehab. And so you have in drug cases, you have family members, and I've had this happen to myself a lot. Family members decide, yeah, we're not going to get Junior out right now. We're going to let him sit there for a couple, 3 weeks and get completely dried out. Because if we go get him right back out again in 2 days or 24 hours, he's not even going to be clean. He's going to still be high. And we don't want him back out engaging in the same behavior. And so while he may get out, it may be a little while longer down the road. The family's made other arrangements. They don't want that person out right away just because of the situation there, and particularly related to drug cases.
Well, that's 100% accurate. And I can say that's something that I've seen professionally, obviously, for almost 3 decades. And I've also personally, I've got family members who are seriously addicted, and the system in California that allows them to just walk out the door without being detained for hard drug possession and other crimes is a terrifying thing, because we want them to be held. We want them to be forced into treatment. And the zero bail certainly doesn't allow that to happen. So I agree with you 100% on that.
Well, and what a lot of people don't seem to understand is, when they talk about those, is drug cases generally are not considered violent crimes, even though they spark lots of downstream effects, both property and violent crimes. That intervention at an early stage can help prevent lots of crimes downstream.
Yeah, totally agree. I mean, drugs are at the root of so many of our problems in society. And, California, that's one of the other big problems we have here is hard drugs are essentially decriminalized. It's a misdemeanor ticket. Possess fentanyl, methamphetamine, heroin, cocaine, PCP, which is what's fueling our crisis, our homeless crisis and crime crisis.
Well, let's get into politics just a little bit on this. And it's kind of a long question, but ever since 94, following a series of events, we had seen significant reductions in crime from like 66 on to like 92, 94. Violent crime especially was just on an exponential rise, and then you started to see it sort of taper off. The Bureau of Justice Statistics report that I referenced earlier caused a shift in the prevalence of surety bail releases. And in 1992, that report showed that 60% of pretrial releases were non-financial and 40% were some variety of secured release. By 2004, those percentages had flipped. President Clinton's 100,000 new police officers initiative had fully gone into effect, and you were seeing a drop in crime. Prison populations had increased, but crime was falling, so we were probably locking up the right people. And while we're not back in the bad old days of 2,000 murders in New York City, crime has definitely exploded over the past few years, and we can't even find people to work in law enforcement. It's a pejorative when you say that you're a cop anymore. And our stores have to lock up their products where people can't even walk in and shop. But what happened? What happened politically? How did police and prosecutors become the new bad guys in this whole situation?
Yeah, wow, we could talk for a long time about that. And I agree with everything you just said. In California, this is my experience, California, my entire career. This turn in events really started about a decade ago in California when two things happened. First of all, they made the decision at the legislature to move a lot of the serious and violent, the non-serious and non-violent felons from state prisons to the local jails. They called it prison realignment, and it was Governor Jerry Brown at the time was the one who ordered that, and that had a profound impact on our jails being overwhelmed with people that previously were in prison. And many jails were forced to start releasing people having served only a small fraction of their sentence. So you started to have more and more criminals being dumped onto the streets, not getting rehabilitated at all. And then right on the heels of that, in 2014, California voters were duped into passing what's called Proposition 47. It was given the name the Safe Neighborhoods and Schools Act by our then Attorney General Kamala Harris. And that act did a couple of key things that have just destroyed so much of California. The first thing it did is it decriminalized hard drugs. It took it from a felony to a misdemeanor ticket, essentially, for those hard drugs, fentanyl, heroin, cocaine, meth, and PCP. And we were talking about carrot and stick earlier. Prior to Prop 47, we had very robust drug courts where people who were arrested for those offenses would be compelled into a drug program, a drug treatment supervised by judges, and it was very successful. Post Prop 47, we have no stick. Our drug courts are gone. People simply don't show up to court at all. We do have good data on that, and they live on the streets, most of them, and steal to support their habit. The other thing Prop 47 did is it changed the laws around retail theft. So we no longer in California can charge recidivists who steal every day, 10 times a day, every day of the year. We can't charge them with a felony if their theft is under $950. And so those two things have really fueled it. And then we've had a few other massive reforms in the last decade that they just completely, they flipped the trajectory of California, which used to be a pretty thriving business economy. Mm-hmm. There was a feeling of safety. It's not to say there weren't things we could have done to improve the system, but we went way too far. It hasn't let up entirely yet. It's a one-party state. They control every office in the administration, and it's become very radical.
And just as an idea, I know that Kansas, one of the things we have here is, granted, we have a higher minimum threshold for misdemeanor to felony. It's $1,500 threshold. But one of the things that we do have is that if you are caught shoplifting 3 times in basically related events, so if you go to the mall and you hit 4 different stores and steal, $500 from each store, we can still charge you with a felony because it's a repeated offense over a small period of time. So I don't know if California has that, if there's any workarounds to where you can get people charged with that. It sounds like
we don't have that in California. It's called aggregation, and the aggregation law is insufficient in California. We're not able to add up those smaller amounts to get to the felony threshold, except in very, very unusual circumstances. And so, for the vast majority of our prosecutions, we're stuck with a misdemeanor if the value is under $950, even if it is, 10 times a day.
Right.
And so, the law is totally broken in California. There's an effort right now to fix it. There's a statewide effort involving law enforcement, DAs, sheriffs, police chiefs, retailers, leaders, mayors to amend Prop 47. We're hoping to get that on the November ballot. It's called the Homelessness, Drug Addiction and Theft Reduction Act. And our goal is to get it qualified, get it on the ballot in November, and hopefully, the voters pass it. I think they will. The polling shows they're 70% support it, just based on the title and summary. And that will be a game changer in California.
So it might actually be a bill that does what the title says it does.
Yeah, it's not a bill, it's an initiative.
This
is straight from the people. So that's, I guess, why this would work is we're not going to the legislature because our California legislature has no appetite to do anything like this.
Well, no, the legislature essentially outlawed bail, and it took a public initiative like that to actually get it put back into, or to stop it from going into effect. But I would like to talk about, and maybe you can provide some better information, is the Humphreys decision. I know you referenced that in your report, but the Humphreys decision, if I recall the situation right, it was a person who had a pretty severe, elderly person, but had a pretty severe prior record, essentially engaged in what would have been a home invasion robbery, and ended up stealing a bottle of perfume or cologne or something like that. But it was still a home invasion robbery and an aggravated robbery, that sort of thing. And his bond was set particularly high, and it actually went up to the California Supreme Court, if I'm remembering this all correctly, and they determined that because he didn't have enough money, that the argument's been that case establishes a right to affordable bail in California. Is that correct, or is that just what people are saying outside of California?
Yeah, no, the Humphreys decision stands for the proposition that a magistrate at the time of setting bail must consider the person's ability to pay and the seriousness of the crime and public safety factors generally. It's not a bad decision, in my opinion. I mean, I think judges have that inherent authority to, deviate from the bail schedule if they believe it's appropriate. And so it really, in one way, the Humphreys decision in California has taken away, the argument from the bail reform folks that say, bail just, prejudices poor people. Well, no, in California, the judge has the authority to consider the person's ability to pay in setting bail. So it is being considered and weighed as a factor by an independent magistrate. And that's a talking point that often goes, just they don't want to bring it up, because if you did talk about it more, it would help people understand that California actually already has a system that considers those factors that are so concerning to the reformers.
But it's just one factor out of a holistic decision then. That's right. It's not preeminent over all the others. It doesn't matter what your prior criminal history is. If you only have a nickel in your pocket, we can't set your bond higher than a nickel.
Yeah, no, it's just one factor. And those other factors I mentioned are all equally weighed by the court.
Now, I noticed in your last election that you were running against someone who was a former public defender, and I've had that happen here. A couple of our offices here, one in a neighboring county is actually won, and I think the consequences have been, a much looser approach to criminal justice than we had before. The local paper here, which is very, very liberal, it has always criticizing him for being too soft on crime issues, and the local police are unhappy with him, but he keeps getting reelected. But public defenders as district attorneys, I know you said you started out in the public defender's office for a little while, but these long-term public defenders, it's one thing for a long-time prosecutor to go into defense work, but the opposite doesn't, at least never used to happen. But now we're seeing this whole raft of public defenders running for DA. Gascon, Larry Kratzner out of Philadelphia, a handful of other ones that have come in and taken a public defender approach to that. Does the public defender, a person coming from that background, do they have the right mindset, you think, to be a prosecutor?
I think they can, because I am familiar with folks who were public defenders or criminal defense attorneys who I would say they're not true believers. Right. They're more pragmatic, and they understand, look, the beauty of our system in this constitutional republic that we're in, and with the justice system, is you have an adversarial system. And, thank God we do, where both sides get competent lawyers and you get an independent magistrate. So people that do the defense work, if they're not true believers, I think can make that cross to the other side and be effective prosecutors. But I think the point that you're bringing up is that many of these folks that are being elected as DAs are former public defenders or true believers, like people who just believe that everything I just said is a lie, and that the Constitution is corrupt, and that the system is corrupt. And, I've run against public defenders who refuse to say the Pledge of Allegiance during a debate, and believe that, the system is systemically corrupted and racist to the core. And that's the person that's getting elected to be the chief law enforcement officer. That's terrifying. And so that's what, that's what I say to that, is you got to be really careful looking at these individuals. What do they really believe?
Well, is that something that is coming out of law schools, or is that, because I know traditionally it's always been, the argument for a public defender was, we will make sure the Constitution is upheld, come hell or high water. And, it's not our job to get criminals off, but it's our job to make sure the state meets its burden. And it just seems like there's been a change in philosophy over the past maybe 15 years on that.
Yeah, agreed. I mean, I've seen it here with our academic institutions, and our law schools are definitely much more pro-defense, progressive ideology to an extreme that, I have several law schools that I recruit from right here in my area. Sacramento and UC Davis has a great law school, University of California. But it's true that the vast majority of students that we are meeting and talking to have, been fed a narrative about the system and prosecutors that we find to be inaccurate and mostly, very progressive leaning. So that's a challenge. I mean, I think part of the challenge for our profession as prosecutors across the country is to push back against that false narrative, and to actively recruit people at an earlier age to join our profession as truth seekers, and reject this idea that, the system is corrupt to its core. That's not going to get us anywhere.
Well, and we bought a house a while back, and the previous owners, their daughter was in law school at University of Kansas Law School, and she was didn't even realize this was a major, but she was at law school with an emphasis on social justice. And it's like, what is that? I mean, what type of law are you practicing that qualifies as social justice? I mean, because you've got environmental law and criminal and civil and all the various forms, but I hadn't actually seen, a docket for social justice.
Yeah, I mean, that's interesting. We've got a lot of that in California. So, and it's interesting. I told you I'm in a deep blue county, and I told you California is a deep blue state. So, those folks, candidly, they've been in control out here in our legislature and the criminal justice reform movement. Those are the people that have had the power and are shaping the system here. And I hate to say it, but a lot of times what happens in California rolls across the country, and that would not be a good thing in many ways. So, my hope is we can turn the tide a little bit this November with the initiative I was talking about. I will say that there does seem to be change with moderates in California, moderate elected officials that I'm talking to daily. Again, I'm right next to the Capitol. They're coming around a little bit. I think the crime data, and maybe it's just a result of political season, but they're definitely posturing about being a little bit tougher on crime than they've been before. So we'll see.
Well, and that was sort of, and you probably would be more familiar with this, but the Buffin case out of San Francisco that was challenging, bail in California, that the Attorney General's office, when, as you mentioned, Kamala Harris was the Attorney General, had defended the first of these cases and won. Bail was perfectly legal. There was no right to affordable bail. It was I think it was a strict scrutiny standard or whatever it was. Just fine, no problem. Then Buffin came along, and we started looking at running for Senate, and then it wasn't popular anymore. And so, even though she was the Attorney General of the state, and it is her job to defend state statutes, the AG's office walked away and wouldn't defend the lawsuit.
Yeah, that's right. Yeah, I remember that, and that's part of the reality of politics. And in California, the Attorney General is a partisan position, unfortunately.
So. Obviously, crime is a problem, but what can we do going forward? How does the Democratic Party distance itself from this radical anti-law enforcement stance? Because I believe, and I think you've referenced here, that most Democrats are, in fact, like you, law and order. They don't like this law enforcement lawlessness any more than Republicans do. There's an old saying that a conservative is just a liberal who's been mugged. How do we shift the tone and tenor without requiring everyone to be a victim of crime? How do we get back to common sense?
Yeah, it's a great question. First of all, I'm not a Democrat. I'm a proud independent. And as a nonpartisan office holder in California, especially one in a deep blue county, I embrace that. And I'll just say, this, but I don't ask victims if they're a Democrat or Republican, and I don't care. I don't care what the defense are. But I'm aware of the politics, and it certainly plays a role into a lot of the policies, not only in my county, but the state. But I just think we got to get back to, pragmatism and finding solutions in the middle on some of these issues. And I'll use a lot of my own programs as examples. I was able to implement a implicit bias training program that I think is helpful, and a race blind program that I think is helpful and builds confidence, whether you're Republican, Democrat, or anyone else. I don't think anybody would argue with this idea that Lady Justice is blind for a reason. And if we can do something to honor that tenet, we should do it. And so, we did that without compromising public safety. That's a pragmatic solution that builds confidence in criminal justice, but doesn't harm victims or the ultimate public safety outcome. So I try and stay away from hard ideologies.
Right.
And I think maybe that should be the goal. I know that's not impossible in Washington, D.C., and I know it's impossible in a lot of state houses. It certainly is impossible in the California State House at the moment. But in criminal justice, I think it's really disastrous to go too far either way.
No, I agree. I've made this argument that that's one of the pillars upon which any society is built. You have to have laws, you have to have rules, and you have to have the ability to enforce those. And if you take those away, if you have a three-legged pillar and you take one of those legs away, ultimately it's gonna collapse.
100%. And honestly, that's what we're seeing in California. I mean, you're seeing the stories, what's happening in San Francisco with dozens of stores closing, streets are overrun. It's not just San Francisco, by the way. It's Sacramento. Sacramento is 5 minutes from where I am right now, and it's an absolute hellhole in certain places of the city. It's true in LA. It's true in San Diego. It's true in any major urban area. You go there and you wonder what has happened to our society. And California is, people will say I'm hyperbolic for saying this, but we're going down the drain because we've gone too far in decriminalizing illegal conduct, and we've stripped our system of accountability and deterrence. And look, a lot of people are leaving California. A lot of my friends, a lot of family members. I mean, the data shows every single year for the last many years, people are fleeing California. And the first ones to flee often are police officers who retire. And so I always say, when the folks who are on the front lines start running for the exit first, there's a major, major crisis. And that's where California is.
Yeah, my next door neighbor who just moved in last week, a refugee, I guess, from San Diego. She can work remotely, and so they just picked up and left, and now they're in rural Kansas.
Yeah, look, it's not a great place to raise a family anymore, and I say that having two small kids, and it's really challenging when I take them out in public, and you have to explain to children, why are people allowed to sleep on the street or use drugs in the median or walk out of the store without paying. I mean, that's real. That's happening all over California.
Well, that's just not sustainable. I mean, it just can't be. I mean, we can't continue on that way. I mean, or basically you'll just hollow out these cities.
Well, that's what's happening. I mean, that's the fact. So, but I'm committed to doing my part in my little section of the state, and I'm happy to say that there's a lot of good people working to make this right, mostly DAs and sheriffs, police chief, bondsmen are part of that. And we'll see, if we can turn the tide a little bit, at least out here. But I'm happy that we were able to chat. Thank you for having me today.
Hopefully we can get there. And Jeff, thank you for taking the time to talk to us today. Hopefully you can get things turned around in California. As you said, as California goes, so goes the nation. So we definitely need people like you on the front lines of this fight.
Thank you, Shane.
Thank you. We want to thank our guest, Jeff Reisig, the District Attorney of Yolo County, California, for taking the time to talk with us today. It is vitally important that we have actual real-world data so that we can all make good, informed decisions that are truly data-driven and evidence-based. We hope that you'll join us next time for another episode of the Bail in the Midwest podcast, and we will continue to try to bring you this sort of important information.
Join us again next time for the Bail in the Midwest podcast, hosted by Shane Rolf.